And we are live on YouTube, and I'm now going to let everybody in. So welcome. All right. And we are the Renters Alliance, and this is our Renter Town Hall. And we're just opening the doors and letting people in. It takes a couple of minutes, but welcome. You're looking for the Renters Alliance Renter Town Hall. You found the right place. We're just getting started. It takes a minute or so to let people in. Welcome, everybody. Wait till we hit a magic number. I haven't decided what that is yet, but I think we're shooting to 35. But we'll see. This is the Renters Alliance Renter Town Hall. We'll get started in just a couple of minutes. It takes a few for people to get in. All right. Well, looks like we've exceeded my magic number, so let's get started. Good evening, everybody. My name is Matt Losak. I'm the co-founder and executive director of the Montgomery County Renters Alliance. We are recording and we are live on YouTube. This is one of a series of renter town halls that we provide about twice a month. And this evening, we're going to be focusing on services offered by the Attorney General's office, as well as services offered in Montgomery County. A couple of things. If you have questions or concerns, please put them in the chat. We will be monitoring the chat and make sure that at the appropriate time in our agenda this evening, we allow questions to come in to our panel of experts. Let me quickly introduce who's here with us tonight, and then they can introduce themselves a little bit further when it's their turn to speak. We're joined by Frank Demaray, our Deputy Director of Housing and Community Affairs, Rosie McCrae Moody, the Manager of the Office of Landlord and Tenant Affairs, Amanda Harris, who's the Director of the Services to End and Prevent Homelessness, and has a number of other hats in Health and Human Services, my two staff members, Dave Mullins and Pat Beckham, and the chair of our board for the Renters Alliance, William Roberts, whose S I left off of his last name. You can change that at any time. But to open us up, William, would you give us some opening remarks?
Certainly, Matt. Much appreciated. And as long as you didn't hit me with the Robert Williams, which I have gotten all my life, so it's okay.
Or Elton John.
Fair. Although I'm a huge Elton John fan. Good evening, everybody, and welcome. As Matt said, my name is William Roberts, and I have the pleasure of being the chair of the board of the Montgomery County Renters Alliance. For those of you new to our town halls, or if you don't know much about us, we are the first and only regional nonprofit dedicated specifically to tenant outreach, organizing, and advocacy. And we were formed back in 2010 as an outgrowth of work that advocates have done around the county. Excuse me, throat's a little scratchy. Formed out of an outgrowth of work that lots of folks have done around the county community members, governmental folks who realized that there was no dedicated voice for tenants. And so we were created and have been working ever since to be that voice. And to be that organized voice to help renters have an organized voice in the county and county government. Just a couple of quick comments before we move to our main program. You know, as folks have been talking for some time through this pandemic about the coming wave of evictions, we called it the eviction tsunami even, you know, where we were really concerned that there was going to be just a ton of evictions crashing onto courts and impacting renters and families and communities. You know, while we know that the so-called tsunami was not produced, what we are seeing is still a very real and very dangerous sort of slow motion wave of evictions that are continuing to increase. And so, you know, the first thing I would say, and I think if you're here in our audience in our town hall, you know this already, but it's worth repeating that we are still in the danger zone, very much so, and still need to keep all hands on deck and, you know, the foot all the way down on the gas pedal in terms of addressing the eviction crisis and getting rent relief out the door. And so if you hear and see, I've started to read anecdotally, you know, pieces in the Post and the Sun and other places saying, oh, the tsunami didn't happen, but that does not mean that the danger has abated for folks. And you all know that, which is why you're here to get the information. The other thing, and you hear our partners talk about this for sure, but you know, federal emergency funds aren't going to last forever. And according to the latest data that we have available, there's between 10 and 15% of renters in our county that are still behind on their rent. And so it's really important that while those funds are out there and that second tranche of funds that's going to be coming sometime soon, you'll hear about that as well, that folks get connected up with the Renters Alliance, to get connected up with HHS and other folks in the county to get the information you need to be able to get into the system and apply for relief to stay in your homes. This is something that impacts all of us, all of our communities. We always say, that evictions, of course, hurt tenants and the families being evicted the most, but the ripple effects impact our communities in lots of ways that we know. Of course, a lot of us have been paying attention to what's been going on in MCPS since the beginning of the year, certainly with the COVID surge, but we know that there are lots of families with MCPS students who are facing eviction or facing that that sort of rent squeeze, excuse me, and certainly caught up in the affordable housing and affordable rental crisis. And so we know the ripple effects that has, for instance, for children and families, and that's just one example. And so, housing is not just another, commodity. It is important to have stable, quality, affordable rental housing. It's crucial to our social health and welfare and prosperity across the board. So that's why it's so important, the work that we do. We and the Renters Alliance have been working on the policy side and the direct services side. Hopefully you've heard or about some of the emergency rent protections that we have at the county level, and we've been a strong voice advocating for that extension. That extension is going to expire sometime this spring. I believe it's in May, right, Matt? And so at some point we're going to have a new conversation about how to extend that, clearly, since the emergency is still ongoing. And we know, certainly we are reasonable and support a landlord's right to make a reasonable profit, keep up with expenses. But, we want to make sure that renters aren't priced out of their homes, especially during a public health crisis that's ongoing like the pandemic. So it's really important for all the work that we're doing here. We're happy to have you all here to talk about how we focus on housing policy, both for during the COVID emergency, but also for the long term. And so we've been proud to do that here locally, proud to do that across the state with our partners in Renters United Maryland, which is a coalition that we started of organizations across the state to work on these issues in Annapolis. And so you'll hear more about that from us. The last thing I'll say, and then I'll kick it back to Matt, as you mentioned, some of our partners here, you mentioned our friend Rosie McCray Moody from the Office of Landlord and Tenant Affairs. Rosie, as I understand, this might be your last Renter Town Hall with us because you are retiring, sadly. Who said people are allowed to retire in this county?
I didn't. She didn't ask me.
And so, so first, on behalf of the Renters Alliance, I just want to up top thank you for all the work that you've done and all the partnership that you provided with us over the years. Rosie, as you know, you always hold a special place in my heart because as I like to say, I was on Rosie's board, on her commission. I was on the Landlord Tenant Commission when I was a younger lawyer with more hair, and sort of got my start as I was starting working on these issues, certainly as a member of that commission, advocating for landlords, for tenants, excuse me. But have always, Rosie, appreciated how hard you and your folks work on these issues and the heart for service that you have. That's like, for anybody who knows you and works with you, I know that that's the first thing that they notice, because one of the first things that I noticed about you many years ago, how much you care about, this is not just a job for you. You're not just teaching tenants about their rights because that's your job, but like, you have a heart for, making sure that people have quality, stable housing, and that there's good relations between landlords and tenants in the county. And so I know you've been working for the county for decades and started before there were child labor laws, right? But we appreciate all of the years of service that you put in, and hopefully you're going to get some well-deserved R&R. So just wanted, on behalf of the Renters Alliance, to say thank you off top for everything that you've done.
32 years is a long time, so I think I need a break.
32
I
years.
love the people of this county, and I love the tenants, and I'll still be around, so you may see me again.
We'll be calling you.
Okay. Matt has my number.
Well,
I ain't letting you go.
Well, but we won't let you go, but we will let you relax.
Okay, thank you.
To relax it, but thank you so much, Rosie. And with that, I want to welcome everybody again. And Matt, I'll kick it back to you.
All right. Thank you, William Roberts, with an S. Okay. Amanda Harris is an extremely busy person, as we all know, and she has got a critical assignment this evening to do, I believe, a homeless count in the county. And so we've asked her to go first tonight to give us an update on the COVID rent relief program and answer any questions that we might have. But Amanda, we turn it to you.
Great. Thank you, Matt, and thank you for accommodating me, and good evening, everyone. As Matt alluded to, yes, tonight is our annual homeless point in time count. This is something that happens across the country the last week in January, where communities go out and count people that are sleeping outside in cars, in doorways, and then also people that are in our emergency shelters, so that we can get a sense of how many people are experiencing homelessness in the country on any given night. So it's really important work, and we are hopeful that this year will be similar to last year's point in count, where we actually see a reduction in the number of people experiencing homelessness because of our efforts to provide rent relief. We have already seen, so we count homelessness in a couple different ways. We look at it just on this point in time, but then we also are looking at the number of people annually served in our homeless continuum. And over the last year, we have seen a 20% reduction in the number of people entering homelessness, and a significant reduction in the number of people entering homelessness for the first time, which again, I think really speaks to our efforts to provide rent relief and to really ensure that those resources are going to those most in need. And I also just want to echo William's concerns although I never believed that there was going to be a tsunami of evictions, I did and still believe that the economic impacts of COVID are going to be with us for a long time. So even though there may not be a tsunami, there is going to be a very hard and heavy rain for a long time that we are going to have to face. And I think as a community, we're going to have to come up with other ways of addressing the longstanding affordable housing crisis that has just been exacerbated by the pandemic. This rent relief money is going to run out. We have funds right now, but we've been picking up the pace and we've been able to serve more people. So it's not going to last forever, and people are still going to be in need. So I'm looking forward to working with Renters Alliance to come up with some longer term strategies to try and keep people safe and in their housing. So that's my intro spiel. Now I will get to the numbers. So we have done 3 rounds of the COVID rent relief, and in total we have put out $65 million in assistance. And have served over 9,000 households. So that's over 9,000 evictions that have been prevented due to our efforts. For this current round of that 65 million, it's been 47.1 million, and we've served 4,636 households. We closed the application portal at the end of December. So that did close on December 31st. That last week, we did see a spike in the number of applicants. We received about 400 and some applicants when we were averaging around 100, 150. To date, we have about 2,000 applications that still need to be processed. Since we haven't been receiving new applications, we have again been picking up the pace, and we've been able to close out about 500 applications a week. So if we continue at this pace, by the end of February, we should have completed all the applications for the current round. We are seeing, as of late, a higher percent of applicants that are being denied. And one of the major reasons for that is lack of responsiveness. So for all of the renters and tenants that are here, if you get a call from the county, please answer it and get back to us. We want to be able to help you. We do recognize that some people may have just moved on, but we can also offer relocation assistance. So if people are still in need and they're unstably housed, and you had a previous application, still pick up the phone so that we can provide some assistance. For those of you, I did see a question in the chat. If you have been denied and you feel like you have more information to provide or your situation has changed, you can certainly reach out to us. The best way to do that is to reach out directly to the caseworker who sent you the denial letter. You can also reach out to us through 311. You can email us at hss@montgomerycountymd.gov. But the fastest way to do that would be to actually respond to the person who sent you the denial letter. And we have been able to reopen several cases. And if information has changed or we closed the case because you weren't responsive, maybe you were in the hospital or you were away, we're always willing to reopen that case. As of right now, with the current applicants, the remaining funding for this tranche, we have about $4 to $6 million left. We have committed to everyone that applied before the deadline that is eligible will receive funding. So even if we run out of money for this tranche, we do have another $34 million in ERA2 funds. We will dip into that to ensure that everyone that did apply by the deadline is able to be served.
That's news. Thank you.
Yes. So if you are eligible, you will get funding. The new round, I unfortunately can't share a lot of details as of yet. We are still waiting for a formal announcement from the state of Maryland about our state allocation. So the way the federal money works is Montgomery County gets a direct allocation from the federal government, from Treasury, and then we also receive funding via the state. So the state gets money from Treasury, and then the state divvies it out to the different jurisdictions. We are waiting to hear how much we will receive so that we can finalize the details of the next round. We are aiming for the application portal to open in early March. That is our goal. I don't have a firm date, but that's what we are working towards. In the event that you find yourself facing eviction right now and you did not apply, we still have our regular housing stabilization services. So we are able to provide assistance with rent arrears, with utility assistance, with relocation if need be. You can email us, or you can call 311 and we can connect you to our team. If you have already applied and your situation has changed, maybe you have actually received that red and white notice and eviction has been scheduled, or you have received a judgment, you can contact us and we can process your application quicker. And same way, 311 hhs@montgomerycountymd.gov. I will say that the number of evictions has certainly slowed down over the last 2 weeks. We've only had 13 evictions scheduled. 13 is still 13 too many, we know that, but it's not 50. So that does allow us some flexibility the ability to kind of get caught up on the current applications. The courts are not hearing any failure to pay rent cases right now, and it will not be hearing them until March. So again, that gives us a little wiggle room to be able to provide that assistance. I think that's it. If there are other questions, I am
Quick
happy
question,
to.
Amanda. The 34 million, well, you mentioned the state money and the federal money. Is the 34 million constitute state and federal, or can we expect in addition to the 34 million?
So the 34 million is our direct allocation. So we have that in hand, that is ours. We know that money will be available for renters. What we don't know is what we're getting from the state. So for the previous round, we had $31 million in direct from Treasury, and then we got an additional 28 million from the state. So we're hoping that we will get a significant portion from the state, but they haven't told us yet. So
it would be fair to say that we will have on hand at least 34 million, depending on what the state contributes.
Correct. Yes.
That's good to know. That's also two big pieces of news tonight, Amanda, that if you've applied and you're in the system, the funds will be able to dip into the 34, which will be on hand. And there may possibly be additional funds from the state. Good to know.
Okay. I don't know if there's other questions in the chat or.
I just want to emphasize something to follow up on something you said, Amanda. The portal for the third wave of the program, Program 3, closed on December 31st. But that did not mean that the COVID rent relief program closed. It just meant that that particular program and its applications closed on the 31st. HHS, and Amanda, correct me if I'm wrong or add to this, is revamping the application portal and the eligibility requirements of the system to prepare for the new tranche of money. And we'll hear information about that the next couple of weeks. Is that correct?
Correct. That is
Okay.
correct.
So people, when they hear the program is closed, it's not that the whole program is closed. It's just a temporary stop until they reopen again. So people who are still in arrears, who are facing eviction, we will have more information about how to apply and what eligibility requirements there are. Amanda, can you say anything about the eligibility requirements, what people might expect at this time, or is that too dangerous?
I think I'm very hesitant to do that. I will say that.
That's fine.
Yeah, I will just say that we are hopeful that we will be able to offer utility assistance, which we did not do in the previous round. So fingers crossed that we'll be able to do that.
All right, well, we will quickly announce when HHS is ready to announce that information and share it as widely as we possibly can. Amanda, you also mentioned, because we have had people who would not qualify for the COVID rent relief, but who are in arrears in terms of utilities. Can you also mention for people who are facing eviction, who did not qualify for the COVID rent relief program, so just a handful of those resources that you also have available?
Yeah, sure, absolutely. So we have our housing stabilization services, which provides assistance with arrears, rent arrears, also utility assistance. And if the housing cannot be saved, we can also provide relocation assistance. So that would be first month's rent and security deposit. Again, you can call 311 or you can email us if you need that assistance. We also have the state utility assistance program, LIHEAP and MEAP and a number of other things that can provide assistance with both utility arrears, but also provide an ongoing utility subsidy. The income level for that is, I believe, 175% of poverty, which I don't know off the top of my head what that equates
It's not
to.
much.
It's not much. Yeah. And that program is really for extremely low income households. So that's why we are able to use our local dollars to provide utility assistance for households that have higher incomes. And the income limit on that is 60% AMI for our local funds.
AMI is area median income, for those who don't know it. But we will put the link to that information on the page. But just so you know, you didn't qualify for the COVID rent relief program. There are other resources available to help you. Call 311. If you can't get through or it's confusing or you run into an obstacle, you can also contact the Renters Alliance at info@rentersalliance.org. We're also here to help guide you to those resources. Amanda, I know you're super busy tonight, so I just want to say thank you for coming. We always appreciate the authorized information that you can give us, and we'll send you on your way. But thank you very much. If there are any other questions for you, I'll receive them and forward them to you after this meeting. Thank you.
Good evening, everyone.
All right, next on the agenda, our main guest that I did not introduce before because I was saving her for when it was her turn. But we have with us the Assistant Attorney General for Consumer Affairs, Ms. Karen Strawn. Karen has been a longtime lawyer and Assistant Attorney General, has lots of experience in consumer affairs in general, but is also overseeing the part of consumer affairs that deals with landlord and tenant. So I'd like to welcome Assistant Attorney General Karen Strawn.
Hi, and thank you. As he said, my name is Karen Strawn. I'm the Director of the Mediation Unit for the Consumer Protection Division, and I'm an Assistant Attorney General. And I've been with the office for 14 years. Prior to that, I worked for about 2.5 to 3 years for the Maryland Insurance Administration as the Director of the Property and Casualty Complaint Unit. And prior to that, I was litigating insurance defense cases. I've been an attorney for
that long?
22 years, I guess. Yes, that long. And the most important thing that I've done as an attorney is to work for the Attorney General's office, because we do a lot of things to help people when they're having problems with businesses and what we can do to assist people and educate people and help them to know their rights. So that being said, I want to see what the agenda asked for quickly. Okay, so what the Attorney General's office does is we mediate complaints on behalf of consumers when they're having a problem with a business. And we do that with a large variety of topics. Anytime you're having any sort of purchase of a goods or service, you can pretty much rely that you can come to our office, because if our office is not the right place, we are charged with knowing who the right place is to help you in the state so that you can get assistance with the problem that you're having if you are a consumer in any way, shape, or form. The the way that we do this in part is we have a consumer hotline that's available from 10 to 2 during the pandemic. We usually have it available from 9 to 3, but we don't have the staffing that we had previously. So we are only able to maintain it from 10 to 2 on Monday through Friday. But we also have an email available that people can email us, and we email and respond to their questions and concerns in that respect as well. So just to start off, our hotline is 410-528-8662. And our email address is mediator, spelled MEDIATOR, at oag.state.md.us. And while we're talking about the resources that are available through the Consumer Protection Division, I will just mention we also have a health education and advocacy unit. And that unit answers problems that concern health-related concerns other than quality of care. And they also have an appeal division where if you are an individual in the state of Maryland and you get your health benefits denied through your insurance company, believe it or not, you're supposed to know what to tell them that the insurance company or the provider did wrong so that you didn't get coverage. Well, you can then actually file that with our office, file a complaint with our office, and our office will file the appeal for you and try and get the coverage for you, rather than you being responsible for knowing what the insurance company did wrong. So how does the complaint process through the Attorney General's office work? Basically, you file the complaint with our office, and we do have a specific landlord-tenant complaint form on our website that you want to use. And our website is www.marylandattorneygeneral.gov, and it is in the chat. Once you file the complaint with us, we do an intake process. And the first thing that happens with a landlord-tenant complaint is it goes immediately to a supervisor. That means regardless of whether you have documents that you need to provide to us or a lease or anything of that nature, it's going to immediately go to a supervisor who can look at it and determine if this is an emergency situation. We don't do that with most complaints. Most complaints sit and wait for your documents to come in, and then it goes to a supervisor to review the complaint. But with a landlord tenant, because there are so many situations that can be problematic and require emergency assistance, the landlord tenant complaints go to a supervisor who reviews them within a day of them being received. If it is an emergency complaint, we try very hard to get on that right away, and we contact the tenant to find out a little bit more about the situation, make sure we understand everything that's happening, and then we contact the landlord. Some of the things that we consider emergency situations are evictions, obviously, but also if you do not have heat or electricity and you don't know why, or it's been cut off for reasons, even if you do know why, that reasons that are not your fault, or anything of that nature. And we work between you and the landlord to try and mediate those concerns and try and get them taken care of, so that if you are in the process of being evicted, we'll work with you to get extensions of time. We'll work with you to get payment arrangements. If you are behind in your pay, we'll work with them to, during the pandemic, we spent a lot of time working with people to make sure that landlords were not doing illegal evictions, like locking people out of their apartment or cutting off the heat just to get them to get out of the apartment. If it is not an emergency situation, then we will take it in the order in which it's received. We do have a backlog right now, unfortunately. We normally work through volunteers, and we have about 60 volunteers who work with our office, and we take complaints and they mediate those complaints for us while we supervise them to make sure that they're doing everything in the proper manner. During the pandemic, for the largest part of the pandemic, we couldn't have any volunteers work with us at all. So all of the mediations were taken on by the supervisors, and it's a much smaller number, obviously, than what we had before. But we are doing the best we can to try and stay as current as possible and doing the best we can to try and work in situations so that we are dealing with people as quickly as possible so that they don't have situations that are dire circumstances. If you reach out to our office and you are not able to get assistance, we explain to you, we give you a little bit of a primer on, not a primer, but some resources that you can go to for going to court. We are also available for speaking engagements and things like that, though that's been very minimal during the pandemic. The attempt that we do is to try and educate people so that not only are we resolving the problem that they have now, but we're educating them to help them so that they don't have the same type of problem again if they can help it. Because we try to make sure that you understand, what your rights are so that you can be assured that you will get things taken care of. We do all of our mediations through phone calls, letters, and emails. We don't do anything in person. And currently right now, our office is working remotely. So we have people in every day of the week, there's somebody in the office, but we are trying to do everything remotely as much as possible because of the pandemic, obviously. And we now have I think we have 7 volunteers working with us to try and help with the backlog and get things going more, but we just can't bring any more in just yet, just because of how unsafe it is and trying to keep social distancing and all those important factors. So keeping that in mind, if you are in a situation where you are about to be evicted or you are about to come up for a non-renewal and you're trying to get your renewal rates, things like that, that's all things that our office can help with. And that's all things that we can do to assist you. I know that Matt talked about wanting to find out what our office does versus the county offices and how they can help you. And my suggestion, as I said to him earlier, is that it's important to file with any office that can potentially help you. Because if we're able to help you through the emergency situation, you get help immediately, then fine. You can always contact our office and say, I've been taken care of. If you're not someone who would fall into our emergency categories, but we would still help you and you're waiting in the backlog, well, whoever gets to you first, hopefully they can help you. And if they are not able to if we get to you and you're working with another agency, we'll tell you to let that other agency complete their process, because it confuses the issue sometimes to have 2 different offices working at one time. But if you're not successful with the other office, we will then immediately begin the process as well to see what we can do to assist you. So that's basically what we do. As I said, we do it through a mediation process. Mediation is voluntary, so we can't assure you of guaranteed results, but we do have an enforcement division. When we find that we see a particular landlord that is doing the same practice over and over again, that is an unfair trade practice, we can refer that to our enforcement division, who can then take action against that landlord on behalf of the citizens of Maryland, not on behalf of a particular individual, but on behalf of the citizens of Maryland, to try and stop the actions of that landlord that are problematic. And in most cases, if we take an enforcement action and we go all the way through with the enforcement action, we're very successful in getting results for people. That could result in restitution. It could result in stopping particular actions that are illegal or unfair, deceptive trade practices. And it could result in getting people in better situations so that the other landlords see that and know that they can't do the kind of practices that the first landlord was doing that we took an action against.
I think it's a very interesting point, Assistant Attorney General, that your enforcement, if it comes to that, is looking at a systemic or a practice issue for an industry, as opposed to a mediation and enforcement for an individual in dispute. Whereas I think, and Rosie, maybe this is the time for you to weigh in, that the Office of Landlord and Tenant Affairs in the county, and probably similarly in Gaithersburg and Rockville and Tacoma Park, will deal with the dispute specifically between the landlord and the tenant, and not so much the systemic issue that the Attorney General's office might be more involved in. Is that a fair characterization?
Pretty much, we will do systemic issues as they arise, but I think the Attorney General's office is better equipped to do them on a larger scale. Our bread and butter is mainly security deposit disputes and lease disputes. But if it's we've done systemic issues like people trying to charge trash fees in multifamily units, which is illegal in the county. So we've done things like that, but our bread and butter, like I said, is more so, I didn't get my security deposit back. We do a lot of those. But it would be great to work with the Attorney General on systemic things. I've seen the ones that come out and they've gotten large penalties on people, have gotten settlements for a lot of tenants. They just did one, I think last week, where this company was charging people or charging some kind of deposits, had tenants paying deposits monthly, and then at the end, the tenant didn't get a refund. And
There was a company called LeaseLock, and
yes,
LeaseLock works with landlords to take security deposits. And what was happening was that they were taking the security deposits and ensuring that the tenants were paying the security deposits, but at the end of the time period when an individual moved out of the apartment and was looking for their security deposit back, less any damages, they weren't returning any money. And so we took action against them during the course of our investigation, they actually began to go out of business in Maryland and stop doing business in Maryland, but we have done an injunction so that they cannot come back and try and do business in Maryland in the future.
Yeah, because they were collecting the money, but treating it kind of like a bond, but it wasn't a bond. It was a security deposit. I saw that last week. I was like, oh, cool. So,
right.
Good work.
If anybody has any questions for Assistant Attorney General Strawn, now would be the time. Put it in the chat. Dave, do we see anything? I haven't been tracking entirely.
Nothing too specific, just some commentary to Ms. Strawn, but just some commentary about the two offices interplaying. I had I was wondering myself, a quick follow-up. You had mentioned getting involved in someone's not getting offered certain renewal rates or it has come up for renewal. Is there any way you could kind of expand on how that might resolve, a mediation like that might resolve well for the tenant, like it's something you were picturing when you mentioned that?
And you said when somebody's coming up for renewal?
Yeah, you had mentioned that as an example. Yeah, if you could.
Sure. What we would do at that point, first of all, we check with the tenant to find out what who is the person who filed the complaint, to find out what they're looking for. Because our goal is not to mediate for a specific result, but rather to mediate for what the consumer is looking for. And what we would do is if the consumer tells us, I'm coming up for renewal, they're telling me my rent is going to go up by 20%. I can't afford 20%. And I want to find a way to deal with this situation. And so what we would do is, talk to them and say, well, what is it that you're looking for? Are you looking for just a lower rate, or are you looking to stay in this place, but maybe change to a different apartment? If that might be a lower rate in the same apartment complex, are you looking to look for an extension because you can't afford this rent increase and you know that this is going to happen? Are you looking for like a 6-month extension at your current rate to allow you to stay there so that you can then work it out to move somewhere else during that period of time? And we would then mediate with the landlord to try and bring about whatever result the consumer is looking for. It's a back and forth and requires give and take on both sides, but we try and mediate for what will make the consumer happy, not just what the law is. But we keep in mind throughout the problems that are happening and how they react, how they relate to what the law is. Because if they're violating the law, we're going to come out and tell the landlord at some point, this is a problem, you're violating the law. You can't do what you're trying to do. And therefore, we need to step back and try and get that corrected for that person if they're doing something that's completely in violation of the law, even though it's mediation. So we can't force them, but we can certainly let them know what you're doing is in violation of the law, and this is what the law requires.
So one of the things that we do is try to, first of all, protect the Attorney General's office and the Office of Landlord and Tenant Affairs from the issues that many tenants face that don't need to rise to the level of a formal complaint. So we can inform the tenant of what sounds reasonable. For example, we heard in a town hall meeting a week or so ago, a tenant was upset with the landlord because they were having a number of children and they wanted to move into a larger apartment. And the landlord was resistant to doing that without charging them additional rent. Well, you can't exactly force the landlord to give you a bigger apartment at the same rate. It's just not going to happen. Now, they may be nice, you may be lucky. We can certainly see if the apartment is empty and they're not making any money on it. Maybe there's something that can be done, but we can't force that, nor would I suggest that they file a complaint with the Office of Landlord and Tenant Affairs, knowing that they couldn't probably do anything about it, or the Attorney General's office. So we kind of want to make sure that we're seeing a violation. And so when we take it to a landlord tenant or to the Attorney General's office, we're really looking toward, we're seeing a violation of the law, and then we're looking toward either office to enforce the law. And so, Karen, you mentioned that you would tell the landlord that that is against the law, but then how does it escalate exactly to enforcement?
Well, what happens is we look to how many complaints were received against a particular business. Does a landlord do this practice that's an unfair and deceptive trade practice? Do they do it on a regular basis? Are we seeing something, for example, are we seeing something that's not in compliance with the law that's written into their lease? Well, if it's written into their lease, they're obviously doing this to every person they lease to. And those are the kinds of things that we want to take care of and we want to make sure get stopped. So we refer those to our enforcement unit, which we now have a housing unit within our division that deals with these kinds of problems and tries to ensure that we go after those landlords and either get an assurance of discontinuance, settlement agreement, or we actually file suit against them because they're doing things that are improper and they're affecting a lot of consumers in Maryland.
So specific question, a tenant comes in and tells us that they have a lease that says, in their lease, a provision that says, whatever money you give us, if you owe us money for the exercise room or for parking or for any other fee associated with the property, we can take that from your rent and then say that you have not paid your full rent. My understanding is that if you pay your rent and say this $1,500 is my rent, that the landlord cannot by law divide any of that money to other fees and then say you're behind in your rent. Is that true?
That's correct.
Then I'll send you the copy of the lease tomorrow. And that's a big landlord company. And I don't think it's unfortunately unusual.
Okay.
Anything else for our esteemed Assistant Attorney General this evening? We're very grateful for having you. And I've put in the chat the link to the tips for landlords and tenants publication from the Attorney General's office. And I also put the link to the complaint process for the Attorney General's office. But if there are no other questions or concerns, do we see anything else, David?
There was kind of a follow-up on, do we have one more minute? Should I drop it in
We
there,
have a
'cause
minute.
it was a follow-up, and it kind of on what you were saying too about discretion, not wanting to overburden the office. We had a follow-up about considering no just cause laws. What do you do to assist with a non-renewal? So that's just a not offering at all. Is that almost just a don't reach out, or is it still kind of like let y'all know what the consumer is looking for there too, even if that's the case?
No, anything is something that you can reach out for, because we can, at the very least, if we think something is just something that we can't do anything about, we will at least do an acknowledgement to the business. And that means that they'll get a letter letting you know that there's been a complaint filed and this is what the complaint is, so that the business can potentially take some action as a result of that. And it means that we might not do a formal mediation, because we know that the law is saying that there's really nothing that's gone wrong, and we're not sure where you could get relief for what you're looking for, but we'll still send it to the business so that the business will know. And many times that results in the business taking action that will help the individual, because it's coming from the Attorney General's office and it's got the weight of the Attorney General's office behind it.
And in many of those cases that we've seen, while they are protected by not having to state the reason for the non-renewal of the lease, in many, I wouldn't say the majority, I don't really know, but in many of those cases, we see retaliation behind them. And sometimes, shaking the tree a little bit and saying, hey, we're watching this, might get the people to sit up straight and do the right thing, we hope. So I think with that, Assistant Attorney General Karen Strawn, we sure thank you for coming this evening. We put the link to your complaint process in the chat and other information. And we will now turn to our Deputy Director of Housing and Community Affairs to talk about what's new in the county and to introduce his team. And Karen, Assistant Attorney General Karen Strawn, you're welcome to stay, but we also know that you're very busy with all of these backlog, so we won't keep you if you have to move on. Thank you for coming.
Thank you.
So Matt, I'll say thank you very much. Thank you to Karen, very helpful. Puts a lot of the work we're doing in context at the state level. And a lot of things you just heard are consistent with the types of support and information that you can get through county resources. So again, my name's Frank Demaray with the Department of Housing Community Affairs. We go by DHCA. We have folks with us tonight to talk to some of the services that we provide. I like to always start with reassuring you the county is open. Our staff might be working primarily remotely, but we are working and responding, handling record numbers of inquiries and concerns. We know the stress. We know the challenges that Amanda spoke to earlier on ability to pay rent. But in addition to that, there are some fairly consistent and ongoing challenges with respect to tenants' rights, understanding and abiding by the county and state landlord-tenant protections. There's efforts to mediate and support landlords as well, working with their tenants. And then the department's also responsible for the code enforcement, all your housing code and safety issues. I'm going to highlight a couple of general issues. Then we'll have members of the team speak to specific areas of responsibility. But one of the key things that's current and new is that on December 29, the courts that handle the landlord-tenant actions, which are the landlord suits against tenants for possession of the property, and it can be for failure to pay rent, or as was just mentioned, the landlord can choose not to renew your lease. And if you stay beyond your lease expiration, if they give you proper notice, they can take action against you for holding over. And they can also take action if they state that you have breached your lease by some actions. These different types of cases are held in the courthouse in Rockville, and the landlord-tenant failure to pay rent. If you have not paid your rent and your landlord is suing you in the court and asking for the eviction based on failure to pay rent. All of those case actions, new hearings, have been suspended as of December 29. They've now extended, they had initially through the first week of February, they've extended it through the first week of March. So anyone that had a hearing scheduled in January and now in February for failure to pay rent, which is one of the categories, those cases are being rescheduled. And at this point, we expect that all the tenants who were scheduled will have received notice, but anyone that has not or hears about it, and if you have a failure to pay rent case in January, February, those are being rescheduled. That is going to push back all those cases into March, April. So there will be a backlog. There'll be a process that they're going to add some dates to try and catch up on that backlog. But so that's an important thing. It's not a reprieve. It's not a moratorium. It has to do with the COVID transmission issues and the ability of the court to handle that. The other cases for the holding over or the breach of lease are continuing in January and February. They're actually being conducted remotely. And if anyone has dates scheduled for court action on those types of cases, there should have been communication and information about how to connect remotely through Zoom. Information about this is available at the county's website for renters. I put it in the chat. It's the main county web address, montgomerycountymd.gov, and then the / the one that goes to the right, renters, RENTERS, or you can go to the DHCA and type in renters. And we've got a lot of information all on one page, and this is a very specific piece. The other thing
Frank, can I just restate what you just said so we can separate those three things?
Yep.
Failure to pay rent has been suspended and cases have been suspended until March 6th. Breach of lease cases are being heard. That is, if you have a dispute with your landlord over your conduct in the building, your landlord has accused you of some breaking the rules in some way, garbage in the hallway, noise, some other thing, or tenant holding over, you're staying longer than your lease allows, those cases are being heard. And I believe, Frank, that if your case has been heard already before the court closed, that the process of the court leading to writ of restitution and to the sheriff's office is also ongoing. Is that right?
Correct. It's not a suspension of eviction actions. So if you receive a final notice, if you get a red and white notice put on your door, I think it was spoken to earlier by Amanda, we do have some emergency assistance funds for people that might be dislocated with eviction, but you also have contact information at that website I mentioned. Renters Alliance can help you. There's other organizations to help you understand what your rights are. Working with the rental assistance, if you had an application in process and they were speaking to the existing applications in before December, if you have that going on, we can work to identify where that is in process. We can work with your landlord if you've got that final notice, but evictions are being executed. They have slowed down, but they have not stopped. Okay, so I wanted to highlight that, and then for those who've been on the call from the beginning, you heard about and were introduced to Rosie McCrae Moody, who's the manager and the longtime leader of our Office of Landlord Tenant Affairs, and she's going to cover a number of the things that are specific to the current emergency status. We have some special laws that are in place for a little while and other key things to make you aware of and to tell you how the Landlord Tenant Affairs Office will work with you. And then we have a representative from our Housing Code Department, Keen Nichols, who can just address the fundamentals of working if you have code issues in your unit, in your building, how to report those and how that process works. So with that, I will add my voice to thanking Rosie for her extraordinary service and continuing service right up to her departure. So please, Rosie, take it away.
Hello, everybody. I just want to reiterate what Frank is saying. Just because they've suspended the failure to pay rent filings, your landlord can still give you notice to vacate if you don't go. He can sue you for tenant holding over. They holding that hearing. Or if you get a breach of lease notice and you don't correct the breach, landlord can still take you to court. And then it's up to the judge to decide whether they should put you out of your house because you didn't get rid of the cat or whatever it is they said you did. Or you made noise or you were smoking on the balcony, whatever.
That would be me, Rosie. One quick thing that's come in about the notices to vacate. It's been raised in the chat that the difference between a notice to vacate in terms of whether or not you're to be evicted based on the threat versus the court's authority. Can you just make sure people understand?
The landlord can give you notice to vacate and say, I'm not going to renew your lease. And so you need to move by February 28th, the expiration of your lease. That's fine. If you don't go, he has to take you to court. He can't on March 1st change your locks and put your things outside. You can only be evicted through court order. So you have to get an order from the court and in the presence of the sheriff. So the landlord can't say, well, now it's March 1st, get out. It doesn't work that way. But I have a question for Karen. Landlords have a thing up, they put notes on color paper on people's doors. Miss Smith, you owe $2,000. Isn't that a violation of your rights? Because you're sharing with everybody in the building information, personal information that other people don't have the right to know. It's all right for them to tell you, if you don't pay your money, we're going to take you to court. But that should be in a closed face letter. That shouldn't be in a red letter on your, in a red notice on your door.
You're absolutely correct. They shouldn't be doing that.
Okay, because we get that a lot, and we notified landlords of it, but we doing it all the time. We're always notifying landlords of it because they do it. It's like, Miss Jones, you owe $2,000. Well, maybe she does, but that doesn't mean everybody in the building needs to know it. Don't put it on in a red notice and stick it to her door, because it's not Miss Smith's business across the hall that Miss Jones owes $2,000, and they have no right to tell her. So, okay, I just wanted to get confirmation of that, because we tell landlords all the time, no, you can't do it. And I just wanted to hear from the state AG that, no, you can't do it. So thank you. Right now they can't sue you for failure to pay rent, but a lot of people before they suspended it were getting this new notice intent to file summary ejectment. That is not an eviction notice. It's just a warning saying, if you don't pay this within 10 days, we're going to take you to court and sue you for failure to pay rent. That's kind of quieted down because they can't sue you right now. But remember, when they start again in March, it's just a warning. It's not an eviction notice.
It's a warning that they're going to file in court, not that
Yes.
they're going, that they file in 10 days. And then you still have to receive a summons from the court after that time.
That's right. So it's just saying that the process will start in 10 days if you do not pay. The voluntary rent guideline will be issued next week sometime. We've done the calculation, and so that'll come out next week. It's lower than it was, so I have to wait for it to officially come out, but it's not more than 1.4%, which was pretty low, so that's good. And the law is still in effect that the rent cannot be raised higher than the voluntary rent guideline until after May the 16th. So your landlord may hold off on renewing your lease until after May the 16th. It doesn't mean you have to get out. It just means if your lease expires during that time and he doesn't renew it, you just automatically become a month-to-month tenant by operation of law. So if nobody gives you a notice to leave, even if your lease expires, you're still a tenant, you're month to month, and everything will stay the same until you're notified of something different. What else did I want to say? Keen's going to talk about the window guards. And what else is going on? I think that's about it. I do want to say this. We lost an investigator. She got a new job and is now in a different department. So we're short an investigator. We had to redistribute her cases along with new cases. So we're behind because we are getting a sudden influx of cases. I think everybody is kind of moving, people who got behind or whatever, and before they are evicted are starting to move and they want their money back or whatever. So we've got a large influx of cases along with the redistribution of cases from another investigator. So it may take a little longer. Well, it is going to take a little longer for us to act on your cases, but we are working on it and we're doing our best. And
I want to add to that, Rosie, because you talked about the limitation on rent increases on the voluntary rent guideline. So just to be clear, the county's had in place since April of 2020 a limit on the increases on any lease renewal. And it's tied to this number that the county publishes as part of our standard annual reference points. It's called the Voluntary Rent Guideline. Voluntary because until COVID, there was no mandatory associated with it. But since April of 2020, no rent increase notice, no rent increase that the landlord gives you notice on can exceed the voluntary rent guideline until after that May 15 date, so the middle of May. And the number today is 1.4. It will change shortly, and that will be in effect for 3 months. The other thing that was tied to the renewal and extension of that law was a provision that if you have lower income, and there's a table of incomes by number of people in your household, and you can state that you had an impact on your income from COVID, that you can fill out a form, present it to your landlord, and any late fees assigned to your account will be waived. If you're eligible under the terms, it's at the website that I put a few moments ago, but I'm also going to post a link to the form. It's a late fee waiver form. It has to be executed by the tenant and presented to the landlord to be effective. Landlords are not allowed to actually receive any money from you for late fees since the law was signed in November. Any earlier late fees are not impacted, and any late fees that you've paid before that are not recoverable. But you can fill out that form, present it to your landlord if you have late fees assigned to your account, and the landlord has to waive those. So that's a very important thing, and it expires with this cap on rent increases on May 15. Okay, so those are current, and you actually have to take action to realize that advantage. Just to augment stuff that Rosie was speaking to also, but again, at the website, we have listing the landlord tenant support. There's a list of the available legal services. The county has contracts for free legal representation available to any tenant going to court. I just want to repeat that and reinforce it, that even though the courts are closed for failure to pay rent, they are still hearing these other cases. If you have a court action coming, whether it's going to happen in February or March or April, and you've got a notice from the court, we strongly recommend contacting the free legal assistance organizations that are listed there: Maryland Legal Aid Bureau, and a group called the Homeless Persons Representation Project, HPRP, that does not limit itself to homeless persons. So there's legal representation for tenants to help you prepare for court and to work with you in court to help present defenses that are available to you. So, we want to make sure you think about all the available resources, Renters Alliance and others listed there, help you work through any of the things we're talking about, but particularly to work with the court process, the eviction notice process. And then the last thing I just want to add on was that the courts starting in October, started giving that notice that Rosie was speaking to, that, you're going to have a filing against you. That can be confusing, and the support organizations and the county can help you understand that. So just restating that you're not alone. There are a significant amount of free support resources available to you.
And I've seen in
You
the
can also
chat,
call, you
go
can
ahead,
also,
go ahead, Rosie.
you can also call the help center in the district court. They have attorneys on duty and they can also give you advice. And CASA has attorneys on that can give you advice as well.
Right.
Right, and if you don't qualify for legal aid or homeless representation project, the Lorenzo's Alliance has in its back pocket lawyers that you are either pro bono or that you can pay for at low cost. But we ask you to follow those other resources first. Quick question in the chat, which I'm sure that they're not allowed to do this, but with the Assistant Attorney General on the line, no, I've never heard of a landlord being able to charge you for a notice to kick you out. So they actually put a notice to vacate on your door and charge you for creating the notice?
There's no such thing as that.
I've never heard of that either.
That's pretty rotten.
Well, there's no
Okay.
such thing. Let us know
Yeah.
who it is.
It could be confused with just assigning you late fees. The key is if you're late at any point after your due date, the landlord can add late fees to your account. But again, and I just put the link out there to access the form, which has the eligibility on it for the county's late fee waiver option if you're income eligible and COVID impact eligible.
If you're confused by that notice, and you do have a notice that says, we're charging you a fee for that notice, we would love to see that. So please send that to us at info@rentersalliance.org. We will work with the Office of Landlord and Tenant Affairs on that one.
Absolutely.
Yeah, the 2-year lease issue. Somebody had a question about that. If any renewal happening now, when you receive renewal by law, you're supposed to have 90 days prospective. So 90 days before your lease comes to an end, you're supposed to get, or whenever they provide you the renewal, you're supposed to get 90 days notice.
Yes.
The rent cap law, which ends, as Rosie says, May 16th, any renewal that you get before May 16th is
It's
still
capped by the
capped by
voluntary
that law.
guideline right now.
So if you're getting a renewal notice now, take it. And you want to stay in your apartment and you've got a 2-year lease option, which you have to be given by law, take it. If they do not give you the
And
renewal
the
notice until
Rate
after
for the
that,
second year has to be on the face of the lease.
that's right. Both of those increases have to be within the cap and they both have to be on the lease. But if the renewal happens after the 16th, you could be subject to any amount of increase. So keep that in mind. If you're in a commercial property, we are very concerned that there's going to be an explosion of rent increases as soon as this rent cap is lifted. David, do we see anything else?
Can you just add on a clarifier to that then for a question in the chat, which is when you sign that 2-year lease, now then come May, you're still locked in. That can't be increased.
No. Once they issue it, it's out. They can't change it and say it's 1.4 now, but next year it'll be whatever the rate. They can't change it. It has to be on the face of the lease, or whatever they say now is the rate now. The voluntary rent guideline now. If they want to raise it more than that, they have to wait until after May the 16th to issue the notice period.
So take advantage, if you want to stay, take advantage of a long-term low increase, low or no increase. It's a good deal. We are going to see rents, I believe, go up much higher than these voluntary rent increase guidelines as soon as landlords are in a position to do that. So take advantage. Other questions or concerns, David? Do we see any?
I was just going to tack on a quick comment to the court discussions that some of the cases that are going forward, I've heard had to have a Zoom option. Some cases are going forward on Zoom or a hybrid. I mean, if you have all else, just show up. But if you want to call, like Rosie was saying, ahead, get some info, or just check the notice you have. There might be an online option to attend if you still have to go. But then, yeah, I didn't see anything.
Patricia just weighed in. Patricia, there is no, except for this emergency rent cap that is in place until May 16th, there is no rent stabilization in the state of Maryland, with the exception of Tacoma Park. So if you're in a commercial property, your rents can technically go up just about any amount, unless it's so excessive that the Office of Landlord and Tenant Affairs or anybody else believes that it is a constructive eviction. That is so much that it basically will throw you out of your home. But we have seen rents, 3, 5, 10, 15, 20, 30, 40% in a single year. So it is possible. If you're in one of these nonprofit communities, Rosie, like MHP, Montgomery Housing Partnership, I believe those apartments are stabilized because of their relationship to the county. Frank, maybe you know something about others.
Well, those properties have controls because of their relationship to the county. But other than, if you're not in a tax credit or a property, one of those types of properties, there's no rent control. They can raise it as much as they wish after May the 16th.
Right.
They just have to give you proper notice of it.
Right. If you're not sure, let us know. We'll tell you.
But they
what
can
kind
only
of
do it
property.
once every 12 months. So if they raise your rent in February to the voluntary guideline, they cannot do it again until next February.
Right.
And I'll further clarify that if you are in a rent stabilized unit, you will know that you'll be under an agreement. Generally, it limits access or occupancy of those units up to a certain household income. So that'll be a very specific notice. So if you don't have an arrangement with your property manager, landlord, along the lines of a rent restricted or rent stabilized unit, what we're saying is there is no cap on the amount of rent increase, and that when we get beyond this May 15, there will be no specific remedies other than to relocate.
And just so everybody knows, the Renters Alliance, we're an independent nonprofit. We're not part of the county government, so I can say this, but we absolutely support a rent stabilization program and are fighting for it. And we are also very much in support of law that would make it illegal to evict somebody without a stated reason, which right now landlords can do through the tenant holding over process. They simply give you 60 days notice. They do not have to say why, and they can proceed to eviction. And we believe that is profoundly wrong, as does Washington, D.C., New York, San Francisco, and a whole bunch of other places with long-standing renter protection laws. So with that, I believe that we are good to go to our next person, Frank.
Well, I think we're introducing Keen Nichols. If you just introduce yourself and help folks with better understanding a lot of code questions that have been coming up, and how to file complaints and how we work with tenants.
Sure. Hello, everyone. So within the Code Enforcement Division, we enforce Chapter 26 of the Montgomery County Code, which essentially is the property maintenance code. So my team specifically does the property maintenance at all multifamily apartments across the county. There's about 70,000 units, and we inspect these on either a triennial basis, biannually, or once a year, depending upon if it is dubbed a compliant property, at-risk property, which is once every 2 years, and then and a troubled property, which is once a year. In addition to inspecting these properties on a proactive basis, we respond to complaints. So if there is a complaint, you've got a leak in, kitchen faucet, electrical outlet's not working, your window's not shutting, you've got an infestation, smoke alarm's not working, just anything that pertains to the actual maintenance of the property, both inside your unit and out, those complaints can come to us. You'd call 311 and it would be routed to us. Usually within 5 days, an inspector will contact you. We'll set up a time to come out and do an inspection and work to resolve the case. Rosie had mentioned something, so I just wanted to touch on it about the new law that came in effect beginning of the year, and that's the window guard law. That is a new law in which property owners are required to place window guards or window stops, one of the two, in all windows where there's a child 10 years and younger. Let's see, we are, as open for business. There was a period of time where COVID closed our inspectors down from actually making physical site inspections, but we're back at it. We've inspected about 6,000 units for the first part of the year. We're on track to meet our goals for the second part, and in the process of going through and doing the notifications that we need to do to get inside the tenants' homes so that we can make sure that folks are safe. In addition to that, I don't know if there was anything else that I should say here, that other than, like I said, if you've got an issue, please contact us. The first thing you want to do, and I'm sure Matt would support this, always mentioning, of course, if it's not an emergency and you haven't notified the property manager or owner, please do so. Give them an opportunity to correct the violation. You know how many times that the call to us is sometimes made at the same time it's called to the property manager, where our inspectors have to spend the time following up, only to find that the issue has been taken care of. So within reason, give them an opportunity to correct it. If they don't, then call us. Obviously, if there's an emergency, you're not getting a response and you need someone out there right away, please let us know. We do prioritize things we regard as urgent life safety and aim to get someone to respond that day.
Thanks, Keen. I just want to admonish the folks who are putting information in the chat. We expect everybody to be civil here, and you have a comment, and make it constructive. We don't want to hear any nonsense about people's character. It's just not right. We work closely with all of these departments, and while we don't always agree, we always work collaboratively and constructively, and that's what we're here to do tonight. Keen, on the issue of enforcement, as I know it's frustrating for you as it is for many tenants, when you have an aggregate of complaints, particularly one of the apartment complexes we've been dealing with, that you know very well, and you put in a number of citations, and you're still not getting response from them, what's the code department's process for enforcement and escalation?
Well, it's very rare when we, usually, especially at a bigger apartment complex where you get no response. The violations or issues may not be getting resolved as fast as we would like them, but it's not that it's no response. So I just want to clarify that. When we issue a citation, there's a process obviously to get in court, and that takes some time. But I can't think of like any really issue where we get no response. So I just wanted to clarify that, because usually property managers, owners, especially when they're bigger, they usually are working with us, getting us information, and documenting to us proof that they're on the job. If conditions are so bad that it's people can't live there, we always have the power and authority to do what's called red tag, or condemn a building or a unit, to say, is this totally unsafe to occupy because the violation is so presents a exigent threat to life and safety. So we do have that tool as well. We do use it on occasion where we say like, hey, it's unsafe to live here, and then the property owner has to be responsible for getting them to move and actually pay for those.
In some of these units, Ken, as we've dealt with you on a number of occasions, where we see a citation is given because of a code violation, and then they don't follow up, or we see the same citation being given over and over, or the same complaint, because whatever was broken, like the elevators or vermin or constant leaks from pipes and so on and mold, that the fixes are superficial, but they don't follow through. And so you end up with an increasing sort of aggregate number of complaints leading toward, one would hope, listing the property as a troubled property. But your standard process is you issue the citation. And what does the citation actually mean? The landlord, what is it, a $500 citation? How does it work? What is it?
So we issue citations for per violation and per unit. So if it's a big complex and we've gone back and we've done our re-inspections, it could be several hundred citations. If it's a complaint, it's a many violations that we found in that particular unit. So it might be 4 to 15 different $500 counts. We go to court, what we're looking for, a lot of times by then, they've gotten the issue corrected. But if they had not, then we're looking for a judgment, what's referred to as an abatement order that says property owner, you must do, and it's under court order now, XYZ, and complete it by a certain date. If they don't, then they can be found in contempt of court and other penalties heaped upon them. I've never seen where it had to go that severe, where the judge has thrown someone in jail that's a big property owner. I know that there's been cases where I think, not my own case, but I think I've heard it one time that it's happened here with a particular property owner where he's ordered to go to spend a little time. But
maybe it should happen more often. I think some of our tenants would think so. But anyway, so at $500, then the county, you can refer to the county attorney. The county attorney takes them to court. And one of the challenges that you all face is that if the landlord cures the problem, the judge is less inclined to maintain the $500 fine and oftentimes reduces it. Is that right?
Yeah, I mean, if you can imagine, the court systems are buried down, and as of now, because of COVID, our cases, unless they're an emergency, they're being pushed back as well. Just as the landlord holdover cases and so forth are being because of the situation with COVID. But yeah, what we'll do is, even if the property owner tells us, it's like, hey, we've got it corrected, can we not go to court? What we will do is we'll still try to attempt to get some type of settlement from them to still recoup costs for the county for those inconveniences that the resident had to put up with, and actually put some type of penalty towards them rather than risk it getting thrown out.
So Ken, in just 1 minute or less, can you talk quickly about what tenants could do in terms of repair and deduct?
Yeah, it's a tool that's there. We have not had to use it as such, but basically for certain violations, if they, with the approval of code, could get the violation corrected, but they have to go through us first to make sure that this is an okay expenditure. And yeah, and I don't know the ins and outs of it. I think it's in chapter 29. Rosie, you might be able to speak to it more eloquently of how that works with the rent and so forth. But essentially what it is that there's certain violations in which they, if they're not corrected, they might be able to hire a contractor and get it done themselves.
If code cites somebody for repair and they give them, say, 2 weeks or whatever, and then they don't fix it, but it's an emergency situation that needs to be corrected right away, the tenant then can request from their code inspector, or well, actually the department, that they be allowed to make this repair and deduct it from the rent. And if the department signs off on it, then they can do that and make the repair up to the amount of their rent, I think.
Up to 1 month's rent.
Yeah.
Right. So it doesn't necessarily have to be an emergency. It could be a leaking bathtub. It could be whatever. But if you've made a code complaint, which we urge you to do, and they haven't reasonably responded to the code complaint and made the repair, you can get permission from the code department to get it repaired yourself and deduct it from the rent. But don't do it on your own. Otherwise, the landlord will come after you. We've got one more minute, so let me quickly turn to Frank Desmarais, see if you have any last quick words.
Well, first, I always like to thank everyone that's here, but I also ask if I can engage you as helping us spread the information we're sharing this evening. So a lot of information. We have many thousands of residents to try and reach. So hopefully you have social media networks or communities, connections in your buildings or others that, critical information to support tenants that are in need of information, in need of financial support is available through the county. Support organizations, service organizations, legal assistance are available. The county is available. So I just always like to ask everyone participating, please share this with your networks. We very much appreciate it. We also appreciate how difficult what we're going through is. And so please connect with us. I know I'm hearing in the chat and seeing people who are frustrated with some of our responses. So please let us know. Contact myself, Frank Desmarais, at the county DHCA and the Office of Landlord Tenant Affairs. We do have people responding. Sometimes these investigation complaint processes take some time, but we are doing everything we can on the many thousands of reports that we're receiving. But again, we very much thank you for your participation this evening.
Thank you, Frank. That's Frank Desmarais, the Deputy Director of the Department of Housing and Community Affairs. I want to especially thank Ms. Karen Strawn, the Assistant Attorney General for Consumer Protection, who is with us tonight. Of course, I want to thank Keen Nichols, for Supervisor with Code Enforcement, for being on the beat and keeping us informed. And a special thanks to Rosie McCrae Moody on her last night. You can retire, but you can't hide. We know where you are, and we will keep you engaged whether you like it or not, because we need your expertise and your experience. And I want to thank my staff, Dave Mullins and Pat Beckham, for backing us up. I'm putting in the chat again, info@rentersalliance.org. If you are not getting the help that you need some advice or guidance, that's what we're here to do. And we'll advocate for you and educate you about your rights and responsibilities. So thanks to everybody tonight. It's 8:30. Good night.
Good night, everybody.
Thank you, Matt.